Good morning, and thank you for joining today's webinar on Wisconsin's emergency powers. My name is Kyle Koenen, and I'm the Policy Director at the Wisconsin Institute for Law and Liberty. For today's presentation, we're joined by Rick Esenberg, our President and General Counsel, and Dan Lennington, Deputy Counsel, and who's also the author of our newly released report, More Than a Little Danger, Reforming Wisconsin's Emergency Powers After COVID-19, which is a first comprehensive examination of Wisconsin's emergency power laws. Before we get started, I just got a couple housekeeping items to take care of. First, this webinar is going to be recorded and posted on our YouTube channel later today. So please feel free to share this with your social media or anyone who you think might be interested after we complete today. And then second, at the end of the presentation, we will have time for questions. If you want to ask a question, there is a Q&A box down at the bottom of your screen that you can type in a question. We'll be sure to get to that at the end of the presentation. And also, if the speaker view, if you want to move our heads around at all in the Zoom, you can do that just by clicking on it and moving it. So with that, we'll get started, and I'll introduce Dan Lennington, our Deputy Counsel at Will.
Thank you, Kyle, and thank you for everybody who's watching here. First, I'd like to talk a little bit about emergencies in Wisconsin. When we think about emergencies in Wisconsin before COVID-19, we typically think about these things: floods, tornadoes, forest fires, and propane shortages. You might not know it right now, but we are in the midst of a declared emergency for propane. Every year, the governor declares a state of emergency and deals with these unfortunately routine events. And when we generally want the governor to be able to respond quickly to emergencies, we want the governor, for example, to be able to declare emergency to activate the National Guard or to request disaster assistance from the federal government. One of the basic things we expect from government is emergency response. But COVID-19 is a new emergency. While Wisconsin law seems to work well with routine emergencies like tornadoes and floods, we haven't really tested how our emergency laws work with this new type of emergency. We at Will have reviewed our emergency laws and prepared a report that's comprehensive. And our conclusion is that Wisconsin law does not actually work very well with these new types of emergencies that we are facing. Before we dive into our laws, I want to give a little brief overview of Wisconsin's emergency management laws. So our emergency laws are divided really into two chapters in the Wisconsin statutes. The first one's called the Emergency Management Chapter, and that's Chapter 323. That's primarily where the governor gets his powers, and also there's some powers for local emergency response units. The second chapter is called the Communicable Disease Chapter. That's Chapter 252, and that's the power that the Secretary of Health Services gets and local health officials. So when you think about our emergency powers, there are basically these two buckets: the bucket for the governor and the bucket for the health services. So we've identified basically three major problems with Wisconsin's law. Now, to be fair, in our report, we identify about 13 laws that need serious reform, but we're going to focus today on three specific laws. The one that you might be the most familiar with based on news media and what the legislature has done recently and the governor has done is the governor's power to declare an emergency. This is 32310, and it says that the governor, whenever he determines that there's been a disaster, then he can declare a state of emergency. And a disaster is anything that, quote, negatively impacts life. So this is an exceedingly broad language in the statute. The second part of this law is that the law literally says that it shall not exceed 60 days unless extended by the legislature, or on the other hand, the legislature can terminate it. So on the one hand, Rick, when I look at this law, if you were to ask me a year ago, what's the main problem with this law, I would say, well, the definition of disaster seems very broad, but we seem to be battling over this 60-day limitation. What in your view is wrong with this particular law?
Well, I mean, I think some of the problems here flow from the breadth of the definition. Uh, as you pointed out, a emergency can be just about anything. And because it can be just about anything, I think it's very important for us to begin our conversation today understanding that this isn't just about COVID-19. And we should not allow our thinking to be dominated by whether or not we like or we don't like what the governor has done with respect to the pandemic, because these are a set of powers that can be applied in many, many other contexts. So, if you look at that definition, an emergency could be climate change. An emergency could be racism. One might expect a Democratic governor perhaps to be more inclined to see those things in terms of an emergency. But a Republican governor might see an emergency in the level of unlawful immigration, or a breakdown in law and order, or an increase in crime. And the problem is that once we do that, the governor now has extraordinary authority. That is, and as we will discuss as you move through these slides, the authority to essentially rule by decree. And so because of that, it's essential that we, limit the scope of the law, that is, ensure that, that the law is not being used for ongoing garden variety issues, no matter how important we might think that they are, and that it be, and that even when we have the potential for a true emergency, that it be cabined in certain ways, that it be limited in duration, that there be procedural safeguards, and that there even be some substantive limitations.
So we will talk a little bit more about this 60-day limitation as we go forward. The second statute that we are identifying as a major problem is the governor's power to issue orders. Now, that first power is the power to declare an emergency, and that triggers a whole set of powers that the governor has. And these may be powers that powers to enter into contracts, powers to suspend administrative rules, powers that may, for like example, the propane shortage right now, the governor can suspend certain rules about transportation of propane or the price of propane. But buried in this section about the governor's powers that he gets after he declares an emergency is this power to issue an order whenever he, quote, deems necessary. Now, I put in a little snapshot of right from the statute at the bottom. This is right in our state law. It says that the governor has the power to issue such orders as he or she deems necessary for the security of persons and property. And the governor has invoked this 3 main times so far. He's canceled in-person voting. He has required everyone over the age of 5 to wear a face covering, and he's suspended all evictions and foreclosures. And he's used this particular language, deems necessary, to issue those statewide orders. So my question, for you, Rick, is that when I learn about, the power of the president, the power of the executive branch, on the one hand, we kind of feel like we ought to give the governor broad powers to act in the case of emergency, but it kind of seems reckless here to give the governor an unfettered power that just said, do what you deem necessary.
Right. We all learned, in civics class back when they taught civics, or we learned it by watching Schoolhouse Rock, that our system is characterized by a separation of powers. The legislature makes the law, the executive branch, the governor, administers and enforces the law, and the judiciary resolves disputes regarding what the law requires and how it might apply in any particular case where there is a dispute about whether it's been followed or not. This language essentially allows the governor to usurp what normally would be the legislature's authority. That is, he may make law, right? He may issue any orders that are deemed necessary. Now, when we're talking about a propane emergency and the governor is suspending a few rules, nobody really takes notice. But the pandemic has thrown this into stark contrast because of the breadth and scope of the things that the governor did. The initial stay-at-home order, which basically told the people of the state of Wisconsin that they may not leave their home. They may not go to work unless they comply with certain conditions set forth by the governor. It was really an extraordinary exercise of power. And it may be that for a period of time that was appropriate. But as I said before, we have to begin our consideration of these powers with an understanding that they can be applied in a variety of circumstances in a variety of ways. And so if we are going to allow the governor to issue these kind of orders, something that is this broad, right? Anything that the governor deems necessary, then it's important for us to make sure that we have these temporal, procedural, and substantive safeguards that I referred earlier and that I know you'll be getting to shortly.
Good. So that's the second major problem of the statutes. The third and the final one, which Ricky just touched on a little bit, is a corollary power that's given to the Department of Health Services. And I put in the language there just so people can see how broad this is. And this is also power that the Department of Health Services has regardless of whether there's a declared emergency. It says the department may close schools and forbid public gatherings in schools, churches, and other places to control outbreaks. And then it says that the department can implement all emergency measures necessary. There's that word again, necessary to control the communicable diseases. Now, when I see language like this, immediately I think, closing churches raises an obvious constitutional issue. Are there other constitutional issues that might just sort of flow from this? This, for example, is the main statutory basis for issuing the safer at home order that Rick just mentioned.
Right, and I think you make a good point, Dan, that when we are assessing whatever set of emergency powers are authorized under the statute, they must at all times pass constitutional muster. And so when you look at something like 252.023, an issue is immediately raised with respect to the ability of the government ever to close churches. That this raises serious questions under the religion clauses of the United States Constitution and the guarantee of freedom of religion under the Wisconsin Constitution. Depending upon how it's applied, it may raise significant issues with respect to the right of the public to assemble and the freedom of association. It's not even clear that the government could, in the state of Wisconsin, indefinitely close schools because of constitutional guarantees of a free public education that are in our state constitution. So whatever set of emergency powers that we have in place, they must at all times comport with the Constitution, because the Constitution is prior to and controls both the content and the application of all of these emergency powers.
So before we move into, Rick's going to talk a little bit about some of the litigation that's gone on. I just wanted to kind of show everybody what has been the result of these powers, these three major statutes, how they've been used so far by our officers. If you look on the left side, the governor has issued 31 orders based on these powers. Secretary Palm, who now works for President Biden, she issued 13. And then there were 8 joint orders for a total of 52 orders. If you want to break down what types of orders they were, the 6 of them were the emergency declarations. We've had 6 emergency declarations that, quote, shall not exceed 60 days, 6 times. The bulk of what Governor Evers has done, though, is he's suspended rules. And these are basically things that the public never sees. These relate to DAT cap or the DSPS or different agencies that have to regulate the public. And so there's been some suspension of rules. And then 19 is probably where we would focus our energies mostly. These are orders regulating private conduct. So these are the orders: you have to stay home. You can't have capacity in a restaurant above 25% at one time or 50% at one time. You have to wear a mask. Things that regulate an individual's freedom on a daily basis. Those are 19 of the orders. So that's, and just to give a pitch for our report that it's online, if you open the report and look in the appendix, on the online version, you can click on the hyperlinks and you can see all of the orders issued by Governor Evers and Secretary Palm. You can click on court decisions and read them on there. So it's a pretty good resource if you want to get a handle on what's happened so far. So Rick, I have here a slide with 4 of the main cases that deal with the statewide orders. If you could just kind of take us through what's happened so far on the statewide orders.
Right. Well, you know, I think one of the things that's very interesting when we look at the litigation that has arisen regarding COVID-19 here in Wisconsin, and it's broadly true with respect to litigation in other states, is that litigants have tended not to focus on whether or not some individual liberty interest has been violated. There's been some of that particularly in the religion area, which I referred to both. But there has been a concentration here on whether or not the authority that is given to the government has been exceeded and whether proper procedures have been followed. So Legislature versus Evers was the first case we really saw here in the state of Wisconsin, where, if you'll recall, when the world shut down on March 13th, we were preparing to go into the April election, presidential preference primary, a race for the Supreme Court, some other races. And for a long time, the governor said, I think quite properly, that he did not have the authority to suspend the election. When you think about it, that's really an extraordinary thing for any politician ever to do, is suspend an election. And the governor said he couldn't do it. And until finally, the day before the election, he decided that he could. And he purported to issue an order that essentially said that the election that was scheduled for the next day wasn't going to happen on the next day. The legislature immediately filed an action in the state Supreme Court, and within hours, the court, by a 5-2 vote, held that the governor could not do this. And it emphasized in its decision that although the governor is authorized to suspend the operation of regulations, he is not authorized to suspend the operation of statute, and the election is called for by statute. We went ahead with the election. By most everyone's account, the feared consequence, right, spread of the coronavirus related to in-person voting simply didn't happen. The next case arose with respect to the governor's attempt to extend the safer at home order. And one of the things that I know we're going to talk about is the time duration on the governor's emergency powers under Chapter 323. If you open the statute book and you look at it, you read it, it says that the governor may declare a state of emergency, but that state of emergency may last for only 60 days unless it is extended by a joint resolution of the legislature. The governor declared an emergency related to COVID in, I think it was March 9th of last year. And that state of emergency was going to end in early May. The governor then, recognizing correctly at that point, he's since abandoned this proper understanding of the law, but then back then he understood that he did not have the authority to extend the state of emergency past 60 days. He did not have the authority to declare a new state of emergency arising from the same set of underlying facts. And so what he attempted to do is use Chapter 252 to essentially, he would essentially direct acting Secretary of the Department of Health Services, Andrea Palm, to issue a new stay-at-home order that would extend beyond this initial 60-day period. An original action was filed in the Wisconsin Supreme Court, and the principal argument made there was that under the law, that if the Secretary of DHS wanted to issue an order that restricted the circumstances under which persons could leave their homes, circumstances under which a business could be open, the circumstances under which a person could travel within the state of Wisconsin, that it had to be done through a process called rulemaking. And by that we mean, the process by which when a law is passed, it is claimed to authorize an administrative official, in this case, the Secretary of DHS, to promulgate a rule which is, at least in theory, merely implementing the legislature's instruction. So there has to be kind of authority to make the rule, and then there's a certain process that you have to go through. You have to go through public notice, there has to be a period for public comment. The legislature has certain authority to suspend the rule. It is subject to certain forms of judicial review. There are all sorts of procedural protections that are involved with rulemaking. Secretary Palm did not follow those procedures. She did not make a rule. She issued an order. And our state Supreme Court on May 13th held by a vote of 4-3 that Secretary Palm could not issue a safer at home order, that she was required to proceed by rulemaking. Now, she could proceed by emergency rulemaking. There's a process for that set forth in the statute, but it provides for an expedited procedure, so you can do it relatively quickly. The governor and Secretary Palm began the process following the Supreme Court's decision on May 13th, began the process for making rule, but then abandoned it, saying that, well, we just think that the Republican legislature will block us, and so essentially gave up the ghost. And so for a period of time, there were no statewide orders or rules in effect, or there were relatively few with respect to, it's not true that there were none, but there are relatively few with respect to COVID-19 until we get to the governor's next about face with respect to his understanding of his own authority. And that is what ultimately led to the Fabic and Lindu cases. And what happened there is the governor, after I think initially improperly recognizing that he could not declare multiple emergencies in series arising from the COVID pandemic because the law limits him to 60 days, the governor decided in late July that it turns out he was wrong about his own authority all along. He could do it. And so he decided that he would issue a new state of emergency arising from the COVID pandemic, and he would use this new state of emergency to issue a statewide mask mandate. We filed a lawsuit up in Polk County challenging that. Our concern was not really whether or not people should wear masks or not, or whether there should be a mask mandate. Our clients didn't feel it was necessary in Polk County at that time. But the concern here is that if the governor can declare multiple emergencies in series, then he has effectively read the 60-day limitation out of the statute. And that simply is impermissible. The law doesn't permit it. The statute limits a state of emergency to 60 days. And if in fact the law did permit the governor to essentially rule by decree indefinitely as long as he or she thinks there's a state of emergency, that this would violate our constitutional separation of powers, that even if the legislature authorized the governor to do this, this would create what we call a non-delegation problem, that the legislature would be essentially writing the governor a blank check and handing over its power to legislate. And the legislature may not do that because we all know that the separation of powers that I mentioned earlier, they don't exist for the benefit of the people that exercise them. They exist for the benefit of the people to avoid the concentration of too much power in one hand. So in any event, these lawsuits were filed. Lindu was filed, as I said, up in Polk County. Another case, the Fabic case, was filed ultimately as an original action. The argument here essentially was that the governor cannot declare emergencies in series. That case was argued in November of 2020 and is still pending. The last case, the Tavern League case, is also still pending, and that had to do with an order which limited in indoor gatherings, and there were arguments that that had to be done by rulemaking and raised other constitutional concerns.
So we also have these trio of cases, which are not actually 3 cases, but if you add up all of the different actions, it's probably half a dozen or so. Rick, I think that in each of these cases, Will has been the primary mover. This is litigation against local orders, right?
Right. So what happened? Right. Remember, I mentioned that the Palm decision came down, and the Safer at Home order was found to be unlawful. The Supreme Court said, look, you can have COVID restrictions, right? So, I think that some people incorrectly assume that the state Supreme Court said in May of 2020 that you can't have COVID restrictions. The court never said that. Majority of the court said you can have them, but you got to proceed by rulemaking and with all the associated safeguards and opportunity for legislative and judicial review and public input that comes with that. And as I said, the governor chose not to proceed by rulemaking, didn't want to, go through that process. And so there was, for some time, an emphasis, and still has been an emphasis on local orders, generally issued under other provisions of Chapter 252, which give certain authority to public health officials. The one that got the most attention is the one there at the top, W. Chris and James versus Heinrich. That's actually a consolidation of 3 cases that were brought by different groups of plaintiffs. We represented one of them. That W. Chris is a Wisconsin Conference of Religious and Independent Schools, and we also represented a bunch of private schools and parents of children in private schools. And the issue there was whether or not Dane County could order private religious schools to be closed. And there were basically 3 issue groups that were raised in that case. One issue was whether or not a a local health official under Chapter 252 ever has the authority to order private schools to be closed. If you put up language there earlier, which says that the Secretary of DHS can, close schools, and but the authorization of authority, the grant of authority to local officials doesn't say that, right? It doesn't say that they may close schools. And so the inference that lawyers and judges will draw from that is that if you specify the power in one place and you don't specify that, in a grant to state officials, and you don't specify that power in a grant to local officials, then that power doesn't exist. Local officials don't have it. That was one argument that was made. A second argument was made that for these religious schools and parents who were sending their children to religious school, in-person instruction was an important part of the pursuit and exercise of their faith through the education of their children, and that to deny the opportunity for in-person instruction would be a violation of the protection of religious freedom, religious free exercise clause of the Wisconsin Constitution. And then there was another set of issues that had to do with the right of parents to control and direct the upbringing of their children. So there were liberty claims being made in the W. Chris set of cases. But what the Supreme Court did is issued a temporary injunction against Dane County Public Health based upon the first set of issues, the structural limitations, the statutory interpretation argument that local officials simply do not have the authority to close local, private schools, that power to close schools exists only in the state government. It is not possessed by local officials. And for that reason, the Wisconsin Supreme Court promptly issued an order enjoining the closing of these private schools in Dane County, and they have remained open, and they were open throughout the fall and continue to be open. That temporary injunction was not a final disposition of the case, but it's, it still had to be fully briefed and argued. Was argued in early December of 2020, and we are awaiting a decision there. The Bowersox case essentially is the same issue, although arose from Racine. The Jim Finity case, also a case that was brought by Will, essentially has to do with the ability of local legislative bodies to delegate authority to do things like, restrict gatherings and impose other types of COVID restrictions, simply to delegate that to local public health officials. And the argument there essentially is, there are some other arguments, but the argument there essentially is that it's really a repeat of the argument that I mentioned earlier in the context of limitations on the ability of the state legislature to give the governor sort of unfettered authority to declare emergencies. The argument there is that a local legislative body like the City of Madison Common Council or the Dane County Board of Supervisors can't simply say to a local public health official, do whatever you want. Right. And that's essentially what happened in Dane County. It's the only place where it did happen, where essentially local legislative bodies said, look, the public health official can issue orders and they have the force of law, and you can be punished if you don't follow them. And the argument there is that for both statutory and constitutional reasons, you can't do that. There has to be some type of direction given to public health officials, or some type of procedural safeguards that you can't simply, if you're a local legislative body, tell the public health officials that they can do whatever they want and then wash your hands of what happens.
And I think your audio's off.
Kyle, I think you need to unmute yourself.
Yeah, I'm unmuted. I think Dan's having an issue with his audio here. Sorry for the technical difficulties here. Just take a second to fix.
All right, how about that? Hear me
Now
better?
Yep, that's working.
You know, one of the things I learned years ago is the watching lawyers operate audio visual equipment is kind of like watching a car crash. Just.
All right, is that sound good, Kyle?
Yep, you're back up and running.
Okay, so we're going to move into the reforms that Will is suggesting in our report. And first, I wanted to just bring up this map of the United States that shows the duration that other states allow their governor to declare an emergency. And as you know, our law says 60 days. All of the dark red states, there's about 15 of them or 14 of them in which there is no limitation. And so if Governor Evers is correct that there is no limitation and there is this power to declare serial or stacking emergencies over and over and over, it puts us in very poor company. It puts us in the bottom 15 states in the country that have no limitations on what a governor can do. And that's pretty scary. The best states are the dark blue states. If you see Kansas, South Carolina, and New Hampshire, live free or die. Those states provide the most protections, the shortest duration for an emergency declaration. The other options that we discovered from other states is that some states actually require the legislature to ratify whatever the governor does. They do that in Alaska and Georgia, for example. If the governor issues an emergency order, the legislature has to convene and sort of say, yeah, we agree with what he did or don't agree with what he did. There's also different options for how an emergency can be terminated. Some states actually allow one house of the legislature to terminate the emergency. And then finally, one of the more interesting things is that there are some states that have local opt-outs. Again, in New Hampshire, they allow local governments to opt out. And one city in southern New Hampshire did actually opt out of the governor's emergency and all the orders that they had in New Hampshire. So moving forward, we're going to just highlight for you briefly 5 of the sort of critical reforms that we have identified in our report here. So number 1 is really to fix this problem of how long does an emergency last? And can the governor declare a serial emergency? And so we're proposing in proposal number 1 that we fall in line with the majority of states that have limitations that should be 30 days instead of 60. For several decades, Wisconsin's emergency declaration law did provide for 30 days, but for some reason in 2009, and we're not exactly sure why, the legislature bumped it up to 60 days. So we think that 30 days we should fall in line with the most states. Also, we think that the legislature should specifically say that there can't be any serial orders or stacking orders without the consent of the legislature. And also this idea that one house may terminate the emergency, I think is also a good idea. I think the idea that the governor is actually taking on lawmaking. The governor is taking on a power that he doesn't inherently have. And so that if one house objects, I think that's a good start for limiting this emergency declaration power. So my question for you, Rick, is that let's assume that the plaintiff in Fabic wins and Lindu wins. Is it still necessary to clarify in state law how long this emergency should be?
Well, sure. I mean, so number 1 and 3, the limitation to 30 days and the provision that one house may terminate a declaration of a state of emergency would be changes in existing law. I think they are good changes because the justification to allow the governor to rule by decree is not that we want the governor to do this and not the legislature. It's that because that simply would not be open to us without amending our constitution, so we would basically, elect a, governing magistrate or king, every 4 years. It's to allow an emergency to be handled for a limited period of time until the legislature can get together and address it. And so a 30-day limitation would seem to be perfectly adequate in this case, that you are certainly the legislature can get together and address this within 30 days. Now, you may not like what the legislature does, or you may love what the legislature does, but in our system, it's the legislature that makes the law. So that shortening of 30 days, I think, is perfectly appropriate. With respect to no serial orders, I think I think the law provides for that now. I think that the plaintiffs should win in the Fabic and Lindu cases. I think they will, but I also think that given where we are today, the clarification of the law, confirmation of the fact that these orders are limited in duration is important. That one house may terminate the order, I think, is reflective and runs parallel to what we're really about here, and that is the making of law. You can't pass a law with only one house of the legislature. They both have to pass it. And so if that's true, then the objection of one house to the declaration of a state of emergency would seem to be appropriate.
Our second proposal here is to basically codify the decision in Palm. And what that basically means is that whenever an emergency order is issued by a state official, like the governor or the secretary of health, the idea is that he or she should go through the rulemaking process, provide notice to the public comment, allow the legislature to modify or change or object to the rule. And so this proposal says that orders should be promulgated. This would make the decision of the Supreme Court in Palm a permanent decision as far as the legislature is concerned. There's also a 14-day grace period in here, and this is because our rules provide for what are called emergency rules, but even in an emergency, rules cannot go into effect for 10 days. So this would give basically a 14-day grace period, which would allow state officials to issue these necessary orders, but then would say after that period, you've got to go through the normal process, and which even provides for in case of emergency. So some people may say, the Wisconsin Supreme Court, Rick's already made this ruling, so why would you need to make this permanent?
Well, I think you need to make it permanent because remember, the Wisconsin Supreme Court was dealing with the exercise of authority under Chapter 252. It in fact specifically said that it was not addressing the governor's emergency powers under Chapter 323. So this applies to 323 as well as 252. It also is protection against the possibility that the court will reverse itself at some point. It was a 4-3 decision, and we know that U.S. Supreme Court, the Wisconsin Supreme Court, sometimes they change their mind and they reverse themselves, and they're free to do that. But if we enact a law which specifies that this is the process that we're going to follow in these circumstances, then the court has to follow that, and I think it should and will. And so, so this both extends Palm to 323. It places Palm in statutory law, which I think is important. But yet it does provide for this 14-day grace period. And so when it recognizes the fact that, once again, sometimes you got to act before the legislature can get together. Sometimes you got to act before the rulemaking process can be completed. And so it does provide for that, but it carefully limits the ability to do that.
Yeah, I think one of our goals with these reforms is sort of do no harm. And the rule I've sort of talked about with my colleagues is called the Ebola Rule. I don't know if people remember it, but there was quite an Ebola scare in 2014. There was a scare in Wisconsin. The governor actually took some action. The National Guard took some action. There were Ebola cases in Chicago in 2014. And there was this fear that this was going to spread into Wisconsin. And so I think when we're tweaking these statutes, reforming these statutes, we want to make sure we don't want to throw the baby out with the bathwater. To the idea that if we did have an Ebola scare, or if the governor has to deal with a forest fire, something we talked about before, that we would allow some play in the joints about it.
Dan, we seem to have lost your audio again.
All right, sorry. The third local order goes about that local bodies like city councils or county boards should have to ratify local orders that a local health official like in Dane County or Milwaukee or Racine can't just issue an order without some sort of accountability to the electorate. So, what good does it have, Rick, to have a local county board or a city council to ratify it? What we would say here in Dane County is we'd say, well, they're just going to vote it up. They're going to approve whatever the local health official says. What good does it have to have a city council actually vote on this?
It's that they have to approve it, and that's important. When we consider the separation of powers, and I remember in the argument in the Fabic case, one of the justices asked me, well, look, the legislature could rescind the governor's emergency, and it hasn't done that. So doesn't that mean that this is all okay? And my response to her was, no, it does not mean that it's all okay. Because the legislature has responsibility under our separation of powers. The legislature can't simply either the state legislature or local legislative bodies can't simply step back and say, okay, we are going to abdicate our responsibility and we are going to allow the executive branch to make law. They don't get to do that. They're elected to do a job and they have to do it. And so once again, the idea here is, okay, we understand that there are certain circumstances in which one may have to act very, very quickly, right? And we don't want to get in the way of that. But at some point, it's appropriate, and you suggested 7 days, that the legislature come in and exercise its independent judgment and ratify this and say, you know what, this is okay. We agree with this. We, the representatives of the people, agree that this should be done. This is how we ought to handle this particular circumstances. And that is not meaningless. That is not, a simple formality. It is a requirement that the representatives of the people in our legislative bodies weigh in and say, yes, we affirm that this is law. We affirm that this is what has to be done in this particular circumstance.
So the fourth out of five of our reforms here, this is a reform that would protect constitutional rights by implementing a statute. And the statute would basically say emergency orders cannot confine people to their homes, forbid travel, close businesses and churches, or impair constitutional rights without some sort of judicial review, some sort of judicial preclearance that this is really necessary, and that it would allow people to file a lawsuit, have a right to appeal, and the government would have to pay attorney's fees if they lost. This is an idea that comes from actually the Palm decision. At the very end, the Supreme Court said, basically, notwithstanding everything else we just said about rulemaking, the government simply cannot confine people to their homes, forbid travel, and close businesses. And the Supreme Court kind of said that without much discussion at the end. But I thought it was a great thing that maybe we should just codify this in statute, what they said. So one of the criticisms that I heard from someone when I proposed this idea is they said, you know, Dan, is it really necessary that we need a law that says that the government can't violate the Constitution? So Rick, what would you say to that?
Well, I mean, you know, as I said, I mean, the Palm was a 4-3 decision. Now, it's not clear that a majority of the justices would have upheld a particular challenge to each of these things, right? I mean, you know, Justice Hagedorn, I think, in his dissenting opinion, was very careful to draw a distinction between the claims that had been made in Palm, which were basically a claim that you had to proceed by rulemaking. He disagreed, but he also said, "Well, look, there are other things that claims that could be made here. They weren't made. I'm not getting to that. That's a judicial thing to do." But I think that here this is a substantive, you know, limitation that one should either make clear that no, we can't really go this far by emergency order. That if we're going to do these things that are this extraordinary, if we can do them at all under our Constitution, they have to be done through the operation of regular constitutional order.
Our final suggestion here is the idea of local opt-outs. Now, when I think about home rule or local opt-outs, I think sometimes conservatives seem to have a love-hate relationship with this. And I'm wondering, Rick, what do you think about the idea that you mentioned Polk County, and we had a client that said, we don't think the mask mandate is important for Polk County. What do you think about the idea for people locally to just say, hey, I want to opt out of that statewide order?
Yeah, and look, it provides that the legislature may override it if the legislature believes that a statewide requirement is absolutely essential. But oftentimes in emergencies, they affect different places in different ways, and this is not unprecedented. You know, if you look at the response to COVID in the state of Florida, for example, I mean, it's largely been a local response where the governor has, you know, declined to, for example, issue a statewide mask mandate. Although, you know, if you go to Florida, people wear masks in Florida as much as they do in Wisconsin. They don't need a mandate to do it. But local units of government can, local counties can. And, you know, I think particularly, I think that the pandemic provides a pretty good example of that, in that things were different. That COVID was certainly a threat everywhere, but not a threat everywhere in the same way at the same time, and that some local variation was probably in order.
All right, Kyle, I'll turn it over to you for Q&A.
Great. Thanks, Dan and Rick. And just a reminder that if you have a question, you can type it in the Q&A section down below, and we'll do our best to answer that. And just a reminder that if you have questions after this, feel free to email Dan directly, and we can do our best to answer those as well. So the first question comes from John. In practice, who would have the power to enforce these orders, such as closing churches? Rick, I don't know if you can answer that one. It's a question about enforcement.
I mean, it depends. You know, if it's a local order, it'd be presumably local law enforcement officials. Local law enforcement officials can enforce, you know, specific laws. I mean, you know, but one of the things that we've seen, you know, closing churches would be one thing. One can imagine and be a bit horrified by the notion of, you know, local gendarmes, you know, trying to close a church. Not a particularly appealing thing to imagine. But a lot of times, you know, when it comes to some of the things that have been done in response to the COVID pandemic, nobody enforces them. I am unaware of anybody going down on a mask rap in the state of Wisconsin. I mean, maybe it's happened, but I've not heard about it. The local authorities are, when Madison canceled the holidays and said you can't have private gatherings in your home of people outside your household. Madison police were not going around knocking on the doors trying to find out who's inside, because it simply wouldn't have been viable for them to do so. And so and that's kind of important, I think, sometimes. I don't know that we want the government issuing a bunch of orders that it cannot uniformly and enforce. And a lot of these things do fall into that category.
Yeah, I would just mention, we have a client who's called the A Leap Above Dance Studio, and they were the ones that were fined $24,000 for having a recorded event of the Nutcracker, where there were about 10 children in a room at a time, all masked and socially distanced. And the sheriff actually served the order against the A Leap Above Dance Studio. And so at the end of the day, when these have to be enforced, law enforcement many times is involved.
Great. I have another question from Lane. What limits exist on local government's authority to quarantine or isolate individuals? And what due process protections should apply in those instances?
Why don't you start?
I would say this is probably one of the areas that scares me the most. Our quarantine laws were written primarily in the 19th century to deal with cholera, typhoid, tuberculosis in the early 20th century. And there are few limitations on how government must go about the quarantine power. And also the corollary power is the power to vaccinate. There's a statute that was passed right after 9/11 that says in Wisconsin law that if an emergency.
We lost your sound again, Dan.
Yeah, if I can just jump in while Dan gets his sound back. I mean, that's been one of the uncomfortable things about response to the COVID pandemic, that typically there's a long history in American law of people who are contagious being quarantined. So we all have heard, at least some of us above a certain age, have heard the name Typhoid Mary, right? Somebody who just kept infecting other people and was confined by local authorities. That's one thing. But what we had here in the COVID pandemic was something really extraordinary, where we attempted to quarantine people who were asymptomatic. Now, I'm not saying that there wasn't reason to think that perhaps that is something that should be done, but it's troubling to think that the government could exercise that type of authority over people. It really is an extraordinary thing to do, and it's something that really wasn't done, during the Spanish influenza 100 years ago.
Yeah, I appreciate that. Sorry for my sound, but the one thing I did want to mention before I cut out was that Wisconsin state law does provide that if you object to a vaccine based on religious reasons, the government can quarantine you and your contacts. And there's very few limitations on that. There's no express right of judicial review that's in the statute. And so there is an attempt in the legislature right now to try to fix that. But the language is a little cumbersome right now. But there is this issue about if you don't take the vaccine, you can get quarantined, and that's kind of a scary power.
I have a question from Teresa. So this is a specific question regarding participating in a case. For example, in the city of Racine Bowersog's case, representatives of the teachers union were added in responses. Based on judge's questions during oral arguments, I wondered whether any benefit would have been added if additional parents had responded.
Well, I'm not sure. I'm not sure I know what questions are being referred to. I think that always in public interest litigation, there's an attempt to find persons who are affected by a challenged action in a way which illustrates the legal questions that are being raised by the challenge. And so, the teachers in that case attempted to intervene because they thought that they were affected. And I generally, in my view in litigation like this, is we ought to be fairly liberal about hearing from people in a case like this. So I'm not sure that I understand the specific set of parents that might have added something to that particular case, but I don't know, maybe Dan does.
Yeah, I would just put a pitch in for people who would like Will's representation in cases like this, that they can go to our website and we have a referral form. And we're always interested in responding to people who may have a particular legal issue and want to participate in a lawsuit or like this. So just go to our website, click on Need a Lawyer, and there's a form to fill out.
So I think we got time for about 2 more questions here. This one comes from Catherine, and she wonders what remedies exist, if any, in lieu of litigation are there to stop a governor from exceeding his statutory limitations when it comes to these emergency orders?
Well, I mean, in this particular case, for the legislature, at least if state law is properly understood, the legislature had the ability to end the state of emergency. And it chose not to do so for a number of months. Finally, it did just recently, but the governor made a mockery. I'm sorry. I mean, he thinks he has this authority, and he's perfectly free to to come to court and argue that he does, and he has. But essentially then issued a new emergency order within an hour of the legislature rescinding the old one. And if that can't be the law, because generally what lawyers and judges will tell you is that we don't read statutes in a way that make parts of them meaningless. And if the governor can simply declare a new emergency every time the legislature rescinds an old one, then the legislature's ability to rescind is meaningless. But if the law is properly understood, the legislature has that authority. I think they always had that authority and could have exercised it at any time. And the other thing is that people need to care about process. And one of the things that I think is short-sighted about our public debate and conversation regarding what's happened in response to COVID-19 is that people focus simply on whether or not they like the policy or not. So, we get a lot of heat because we brought a case which challenged an emergency or a declaration of a state of emergency, which was used to have a mask mandate. And people would say, well, wait a minute, I want there to be a mask mandate. Well, maybe there should be a mask mandate, and there are ways the governor could have done it that would not have resulted in a legal challenge, but he chose not to do that. He chose to do it in a way which was, in our view, not available to him. And people should care about that, because how we make law matters. Because even if you love the governor that we have today, I guarantee you that there will be one in the future who you do not love. And so if you want to support exercise of a certain authority in a certain way by a governor or president, then what you ought to do is step back and think about what you would do and how you would feel about it if a different governor or president used that authority in a way that you did not approve of. And I think that sometimes we're very short-sighted in our public conversation about things like that.
All right, and then our final question, I think is a perfect way to wrap this up. What's next, and what will Will and others be doing working with legislators to implement these suggested reforms? I suppose I can take that one. So I think there is an appetite to
just do some work, Kyle.
I'm just answering questions or asking questions here. No, I think there is an appetite to take a look at these laws, and we'll be working with legislators moving forward on not only the proposals we've put out in this report, but other things that they may be working on as well. So I would tell everyone to stay tuned on that. With that, I think we'll wrap things up. If anyone has any follow-up questions, they can email Dan or myself. Dan is dan@will-law.org. My email is kyle@will-law.org. And as a reminder, this video is going to be posted on our YouTube channel later today. So if you'd like to share it on your social media or share it with any like-minded individuals, please feel free to do so. And just want to thank everyone for taking the time out to join us today. Thanks, everyone.
Thank you very much.
Thank you.